If they haven't gotten that, then your tenant is entitled to write a letter to the landlord saying, I didn't get it, and now I'm going to be leaving within any term less than 30 days, and I'll expect a return of my security deposit and interest as provided under the ordinance. So I find that it's very useful for that. There are also, at this point I could mention, there are also some other arguments to terminate leases. It's really not an affirmative claim, but tenants are required to receive a lead disclosure pamphlet from the landlords, and if they don't receive that, federal law provides that no lease may commence until such a brochure has been provided. And I have been informed that there are portions of the brochure that are almost never provided. Even if some are provided, there's always a missing portion under federal law, and so that might provide you with another basis. Now, I should say that I am not personally aware of any case which is specifically held that the failure to provide that lead disclosure allows for that. However, if you read federal law, it clearly provides no lease shall commence, and I think the only reasonable reading of that is any lease commencing where that notice is not given, is not a lawful leasehold. I'd like to make some practical comments on the RLTO. The first is the Lawrence versus Regent Realty Group case, which I think is important because it essentially establishes strict liability for many of these claims. If you prove up pretty much the outline of your claim, there is strict liability. There's no, if you fail to pay the interest on the security deposit, if you commingle it, there's strict liability. There's automatic liability. There is no defense. And I think that that's important because it's really what, in my view, saved the ordinance from potential disaster, because there was a case called Sapilla versus Burke, which came down that said you can only win if you can show that it was willful. And the Lawrence case itself would show you that it was pretty difficult to prove willfulness. In that case, the tenant had a pet, and there was a pet deposit that was asked to be provided as a separate security deposit. Both the original security deposit and the pet deposit both contained in the box on the lease called security deposit. And the landlord, for several years, had paid interest on it in accordance with the ordinance as required. Then suddenly the landlord didn't pay it 1 year. And so my client sent a letter saying, you know, you didn't pay your interest this year, and as a result, I calculate that you made this mistake. Here's my calculation. She put it in the formula showing why the landlord was off the $10 or whatever that 5% was at that time. And please send me something in writing explaining to me, you know, why your calculation is not off and why I'm not entitled to this interest, which the landlord promptly ignored. And then I brought this case. The landlord's explanation for the very first time at trial was, well, as I see it, the pet deposit was really a fee or a charge and not a security deposit. Well, Mr. Landlord, if the tenant had caused damage to her unit through her pet, would you have taken that out of the pet deposit? Yes, I would. And if the tenant had caused no damages, would you have given that back to her at the end of her term? Yes, I would. And if damages had exceeded the amount of the pet deposit, would you then have invaded the security deposit? Well, I've never been faced with that situation, which I thought was, frankly, a ridiculous defense. And yet the judge said, well, I think he made a mistake, and he won't do that again. I'm sure he won't do that again, but I don't find that there's a willful violation of the ordinance under those circumstances, despite the fact that he had been paying that interest on it for years, and then decided suddenly not to pay it and failed to explain in writing, as the tenant requested, why he was not doing that. And as a result, that case was lost at the trial level. It went up on appeal, and the court ruled that as long as I was only asking for one penalty, they were perfectly happy to undo the willfulness portion of Sapilla versus Burke, but that, and therefore there was a violation, which made me happy because that would mean that I would get paid. And then the defendant took that up on appeal, and the case went to the Illinois Supreme Court, which surprisingly took it, considering it only about Cook County and Chicago in particular. and they ruled in a split court decision. They affirmed in a split court decision. Now, there's a wonderful fee provision in the ordinance. And that fee provision is really different from a lot of fee-shifting provisions that you'll see under other laws. Unlike, for example, the Illinois Consumer Fraud and Deceptive Trade Practices Act, the fee provision in the RLTO allows only that prevailing plaintiffs are entitled to fees. And that becomes very useful because you'll see in a number of cases defendants will say, well, of course, if I win, then you're going to have to pay my fees. Since they're not prevailing plaintiffs and they're prevailing defendants, they're not getting any fees. And frequently, I just let them think that to the entire part of the case, never bring it to their attention, and then at the end they get quite the shock when you realize that if they ever win, they're not going to be able to get any fees. An important case to look at is Krasik versus Libetitis, which is a 2006 case. It's citations in my outline. There's no longer stacking of penalties. If they violate 3 or 4 or 5 of the provisions of the security deposit section, there was a time when the judges on the 15th floor, the motion judges, some of them would be giving you stacking or multiple